Hello, welcome to Believers IS Academy, Bengaluru. Today, in the hot topic of the day, we will be looking into the topic of prison reforms, which is very important from mains perspective, and there are also certain points which are important for prelims also. So, we'll be going into the discussion of prison reforms. So, there is a news in recent articles about overcrowding of prisons in India. So, there have been certain suggestions by Supreme Courts, and there are certain recommendations of various committees. So, we'll be looking into those aspects of prison reforms in India. So, why it is in news? So, Indian prisons are facing acute challenges, particularly overcrowding, which hinders the efficacy or efficiency of correctional facilities. Okay, it is facing the challenges of overcrowding. The capacity is less, but the inmates are the people who are convicted and people who are in prison are more. The recent report by Supreme Court's Center for Research and Planning has proposed using electronic tracking devices electronic tracking devices to address this issue, marking a potential shift in India's correctional framework. Okay, instead of keeping the prisoners inside the prison, you can ask them to send home with the electronic tracking devices. Okay, they can be confined to a particular area, a particular house where they will be used tracked by electronic tracking device. So we'll see what is the advantages and what will be the disadvantages. So before this, we'll try looking at report by Supreme Court's Correctional and Planning Center for Research and Planning report. So in this report, the report was by Prisons in India, mapping prison manuals and measures for reforming a decongestion. Okay, in this report, it has given certain statistics about prisons in India. It says that 3 out of 4 prisoners are under trials. Okay, there you should make a different distinction between convicts and under trials. Okay, there are two main terms, that is convicts and under trials. Okay, who are convicts? Convicts are, these are criminals whose offense, okay, they have committed the offense and it has already been tried in court and their crime has been justified by the court and they have been convicted of offenses. Okay, so trial is already done in the court, they have already been arrested by the police, and after the police arrest them, they are sent to the court and the trial has been already done and their crime has been established and they have been punished to the sentences, and they are called as convicts. Who are under trials then? Okay, there is a offense and certain individuals, okay, after offense is committed, certain individuals are arrested by the police and they are sent to the court. In the court, trial is still going on. Okay, you might have heard, like, seen these dialogues in movies. Okay, court is urgent, we will be hearing this case after 15 days. Okay, during the length of 15 days, etc., initially they will be kept under police custody, initially in police custody, but after a certain time of period in police custody, they are sent to the prison. Okay, so they will stay in the prison till the trial is completed. Okay, meaning they are still under trial. These are the convicts, these are the criminals who are like suspicious, like who are put under the trial because of suspicion. Okay, so they are still undergoing the trial. Okay, their offense is not been judged by the court yet. So these are the convicts and these are the under trials. And sadly, in India, people in court, the court is crowded by under trials. Okay, around 76% of the people in court are under trials. 3 out of 4 prisons are under trials in India. And what is the capacity of prisons in India? The total capacity is 4,36,266, but the total inmates are 5,73,220. So occupancy rate is around 131%. So there is a case of overcrowding in Indian prisons there. Okay, so there have been various issues or various measures which are provided by the court and Delhi High Court. We'll be seeing in coming cases. Okay, and out of the capacity, 4,34,302 are undergoing under trials. Okay, so instead of convicts, number of people who are under who are in the prisons are under trials. Under trials are more in prison. Understood? So uh, this is one of the reason for overcrowding in prisons. So the statistics which I already explained, under type prisons constitute 75.5% of the total inmate population, amplifying the overcrowding crisis. And then key recommendations in the report on prisons in India. Okay, the report was titled as Prisons in India, Mapping Prison Manuals and Measures for Reformation and Decongestion. It was recently released by the President of India. According to this report, the recommendations are there should be a phased implementation of electronic monitoring for releasing UTPs, under trial prisoners, to ease prison overcrowding. Okay, if a person is under trial, instead of keeping him in prison, instead of putting extra stress on the prison officers and overcrowding the prison, you can release him from the prison with electronic tracking. Okay, whenever there is a need for a trial, you can then ask him to come to the court. Okay, whenever they are in under trial, they can be asked to come to the court and they can be tracked through these electronic devices. Okay, the target group in the initial phases will be low and moderate risk under trial prisoners with good conduct. Okay, within under trial prisoners, their offenses are they are charged under minor crimes. When they are charged under minor crimes, and if their conduct is good in prison, they can be released. Okay, they can be released through electronic monitoring instead of overcrowding the prison. The phased implementation will assess the community readiness and the feasibility of electronic tracking for a broader use. First, we'll understand how the electronic monitoring can be feasible in India. Okay, this has been already being practiced in many of the countries such as USA, UK, South Korea, Japan, etc. But we have to see what is the feasibility in India, because the society as well as the conditions in Indian society are different compared to different countries. So first we'll see this in the phased manner. If it is successful, then it can be used for broader broader criminals. Okay, first to the under trial prisoners who are not convicted, who are under the trial for smaller minor cases. First they will be released, and if everything goes well, then the prisoners who are under the trial for major crimes, then they can also be released based on electronic monitoring. So before this, there have been certain committees which have been constituted for improving the prisons. Okay, most of the times what happens in Indian prisons is criticized for being overcrowded, and it is criticized for the living conditions of inmates. Inmates are the ones who are living in the prisons, and it has been criticized for the conditions of women inmates. Okay, it has been criticized for the conditions of food, and it has been also criticized for misuse of power by the jailers and the staff in the jails. Okay, the staffs in the prisons. So because of these various issues, there have been various committees which have been constituted in India to look after these issues and provide certain recommendations. And in this one, first committee was All India Committee on Prison Reforms Report, which was also called as Mullah Committee. And the recommendations were, it also recommended a phased implementation of electronic monitoring for releasing the under trial prisoners to ease prison overcrowding, and it also provided that personnel at the prison needs to have the proper training and be divided into various cadres. Okay, they should be properly trained, and they should be trained in such a way that they do not misuse the power provided to them. And then to hire jail staff nationwide, it would also create all India services named the Indian Prisons and Correctional Service. This recommendation is very important. Okay, in India presently there are all India services such as IAS, IPS, IFS, IFOS, etc. So this recommendation, this committee recommended that there should also be an all India services in the name of Indian Prisons and Correctional Services. Okay, and there should also be regular visit by the public and the media to prisons and other correctional facilities, so they can assess the situation and they can assess the conditions of prisoners in the prisoners in the prisons. Okay, and apart from this, there have been various committees. Another committee was Law Commission, which provided 268 report on prison reforms. The committee suggested that persons arrested for crimes carrying sentences of up to 7 years in prison be freed after the serving one third of their time, and those accused of crimes carrying lengthier sentences be released after serving half of their time. Okay, if they are convicted of 7 years of prison time, they should be assessed after one third of the completion of their sentence. If their conduct is good, if the court or prison feels that they are no longer a threat to the society, they can be released. And similarly, if they are convicted for more than 7 years, then they should serve half of their time. After that, they can be released. Additionally, it also advised that the magistrates should not issue mechanical remand orders, and that the police should avoid making unnecessary arrest. Okay, what is remand? Okay, what is remand? Remand is, suppose there is a lower court and there is higher court. The lower court does a trial and sends the case to higher court. Okay, higher court, it will send the case to higher court. Higher court says that you have not evaluated the case properly, and it sends it back to the lower court. When it sends back to the lower court, this is called as remand. Remand. In many of the cases, these are done by lower court and higher court. In certain cases, it is also done by magistrate. And this committee said that you should not just send the case for remanding. Instead, first you should evaluate the case, and if the case needs remanding, if the case doesn't need remanding, you can give the judgment. If the case needs remanding, only then you should send it to the lower courts. Okay, so it said that it should not issue mechanical remand orders, and it should not prolong the under trials. Okay, it should not prolong the trialing process. And then Justice Amitwa Roy Committee on Prison Reform Recommendations. Amitwa Roy was a former Chief Justice or Judge of Supreme Court. He will serve as the chairman of the 3-person committee that Supreme Court established in 2018, and they have suggested various issues on overcrowding. Suggested that there should be a special fast track court to be established to handle only minor offences that had been outstanding for more than 5 years. If there are certain cases, minor cases, which are under trial for more than 5 years, they should be dealt by special fast track courts. Okay, the Indian justice system is so slow that there are certain cases where a person is wrongly convicted of petty crimes such as thief of loaf of bread. They have been put in court for more than 20 years. There have been cases there have been many cases who are under the trial for more than 30 years. Such kind of cases can be dealt faster by special fast track courts. And then additionally, those who have been charged with minor crimes and have been granted bail but are unable to secure surety should be freed on a personal recognizance bond. Okay, if a person who has been charged for minor crimes and they have already been provided bails, but even after providing the bail, they are still kept in the prisons. Why they are kept in the prison? Because they are unable to find a surety or surety. What is this surety? A surety is any person. Okay, it is a person who guarantees to the court. He guarantees to the court that whenever the court asks whenever the court asks the convict or criminal or under trial person to be brought to the court, he is responsible to bring him to the court. That is, he makes sure that the person who is released on the bail is brought back to the court whenever the court requests him for the trial. These are the persons called as surety. Many of the times what happens is, even if they secure surety, they are unable to even if they secure bail, they are unable to find the surety, and until and unless they find the surety, they are made to stay in the prison only. Okay, this finding the surety is very difficult, because in case the person who is charged with certain offences, if he doesn't turn into the court, then this person who acts as a surety will be arrested by the court. So no one wants to take that risk. So they are saying here, this committee is saying that if they are unable to find the surety, they should be freed on a personal recognizant bond. You should sign a bond that in case I don't turn out to the under trial whenever they requested, you can arrest me back again. Okay, this is a certain condition, so that recommendations so that overcrowding can be reduced. Apart from this, there have been other committees. Krishna Iyer Committee Prison Reforms. This Krishna Committee focused more on the conditions of women inmates. Okay, women inmates. It was established by Indian government in 1987. Conditions of women prisoners in there. Due to the special role dealing with women and child criminals, it argued for recruitment of more women into the police force. Okay, because certain issues which are unique to women can be dealt only by the women. So that is a more women should be recruited in the police as well as jails. And the National Expert Committee on Women Prisoners, presided over by Justice V.R. Krishna Iyer, delivered its report in the report to the government by 1988. Okay, in case there is any question of prison reforms in mains, there should be a mention of Krishna Iyer Committee, there should be mention of Mullah Committee, and within those committees there should be mention of All India Services, Prisons and Correctional Services, and there should be mention of this expert committee and women. Okay, and then okay, if these are the reforms, which are recommended by various committees. What are the practices at global wide? Okay, like globally, what are the practices which are being followed? Global practices and legal context on electronic monitoring prisoners. International adaptation. Countries like USA, UK, Canada, Malaysia, and Australia employ electronic tracking to alleviate prison congestion effectively. Okay, if you have seen many Hollywood movies of like United States of India, many of the prisoners will be released from the prison, but they will be carrying a like electronic tracker on their which is placed on their leg, okay, ankle. They will be confined to a particular house or they will be confined to a particular region. If they move out of that particular region, the electronic tracker starts beeping and then the police will come and arrest them again. Okay, and then in India, the legislative framework is like the law here is Model Prisons and Correctional Services Act 2023, which was very recently introduced. It introduced electronic tracking devices as a condition for granting persons prison leave. Okay, it is only looking after prison's leave. If a person is provided prison leave, then he should be given the leave only with the electronic tracking device which is attached to his leg. And then Law Commission for India's 2017 report recognized the cost saving and security benefits of electronic tagging while emphasizing the caution. They said that there is a benefits of using electronic monitoring devices, but there should also be like caution should be taken, because if the person who is convicted of very heinous crimes or like major offences, there are very chances that as soon as he is released from the prison with electronic tracking, he can go back to committing the same offences. And then judicial developments. Judiciary have taken their own certain actions, such as courts have imposed location tracking as bail conditions in select cases. In certain cases, the bail is provided only with the like sharing of location tracking. The Supreme Court recently disapproved of constant surveillance of the bailed individuals, underscoring the need for clear guidelines to balance security and privacy. Okay, they say that even if person is released on the bail, you cannot completely track him down because it is against the right to privacy of that particular individual. And then, so now we'll understand what is the benefits of electronic tracking of prisoners. So first and foremost is it will result in prison decongestion. People who are under trial for minor offences can be released from the prison, so that it will reduce the like stress on the prisons. Numbers will maintain the oversight, and it will also provide mental health benefits. It improves family contact and reduces stress from isolation. People who are under trial and who are in the prison, they suffer from isolation from their family. This can be reduced, and this mental health can be like improved by this electronic tracking. And then cost effectiveness. It cuts expenses associated with the maintaining high incarceration rates. Okay, and then rehabilitation incentives. It encourages good conduct by linking it with parole and furlough opportunities. Okay, what is parole and furlough opportunities? Parole and furlough are temporary release from the jail. Okay, parole and furlough are both temporary release from jail, but the conditions differ. In parole, it is based on the prisoner's request. Both are based on the prisoner's request, but in parole, this prisoner's request can be denied. But in furlough, it is a basic rate. Whenever the prisoners ask for the furlough, he should be provided with the furlough. It is a basic rate, whereas parole can be denied. Examples of parole is conditions which allow for a person to provide parole is whenever there is a family death, whenever there is a family member dies of certain conditions, then that person can be provided parole to visit that family member's death and then like do the whatever the tradition is there. And in like furlough, it is done to break the monotony of the imprisonment. If the person who is accused of, like if he is provided a sentence of more than 7 years, then he should be provided with furlough, so that he can break that monotony of imprisonment. And here parole is up to 1 month, can be up to 1 month, whereas furlough is only for up to 14 days. And parole, it doesn't count in total sentence, meaning if a person is convicted for 1 year and if he is away for 1 month based on the parole, then the person has to serve for 1 month extra, because 1 month of his sentence is being wasted on, he's been taken down by parole. But whereas in furlough, it counts within the sentence. Okay, like parole can be provided for multiple times for various reasons, like family death, like death of family members, and for health conditions, etc. But furlough is very limited. Okay, if a person is convicted for 5 years, he might have the furlough opportunity for 4 years, 4 times. If he is convicted for 10 years, he can have 8 times, etc., etc. So it depends on the imprisonment time also. So the parole is provided by divisional commissioner. He'll first assess the situation. He'll first assess the situation of the individual who is convicted, and then he will assess the situation based on the outside conditions. Okay, and then in furlough, it is provided by Deputy Inspector General of Prisoners. Okay, Deputy Inspector General of Prisons. This is the difference between parole and furlough. And then Indian legislative framework, we already discussed this one. So concerns and safeguards for electronic tracking prisoners is, there is a risk of misuse. Universal applications could lead to misuse, infringing of the civil liberties. Okay, suppose you are releasing a person who is under trial with the help of electronic tracking. He, once coming out, can again turn back to his old habits, that he can also again turn doing into theft, and he can also commit rapes, murders, etc., etc. So there are every chance that they can misuse these opportunities. And potential operational challenges in ensuring the equitable implementation. Okay, since it is an electronic device, there is a chance that the electronic device can get damaged by various issues. Okay, then it will lead to escape of the prisoners. And there are also certain recommendations for ethical issues. That is, there should be clear guidelines for implementation to prevent undue violation of prisoners' rights. Okay, and then there should be strict safeguards to protect against misuse by achieving the goal of decongestion. There should be balance between decongestion as well as balance between prisoners' rights. So there are both benefits as well as concerns about electronic tracking. But the way forward here is to adopt electronic tracking in a phased manner, so that we can reduce the congestion of prisons. So this is about today's topic discussion. Do make notes of important committee recommendations, and also make notes of positives and negatives of electronic tracking. So if you like the video, please like and share with your friends, and also comment on the video, and also subscribe to the channel and click on the bell icon. With this, I will end the video. Jai Hind.